KZN, our colleague Ayanda Mhlongo is standing by with the big story of the day. Ayanda, what's the latest?
Good day to you. Good morning to you, Desiree. Once again, good morning to our viewers. Well, news from the Pietermaritzburg High Court. The former President Jacob Zuma is going to appeal Friday's judgment that was denying him the application for a permanent stay of prosecution. The court just adjourning shortly, and the trial date or the pre-date for trial has now been set for the 4th of February 2020. However, there are several dates that have been agreed upon by the state as well as the defense counsels. Advocate Billy Downer for the state standing up saying that the state from the onset had said that they were ready for trial, and in fact they are now ready, and the ball is now in the court basically of former President Jacob Zuma, and they did indicate to the state that they intended to file the application for a permanent leave to appeal. Of course, from his co-accused French arms company Thales, Advocate Anton Katz saying they had not yet received an indication from their clients, which is the French arms company Thales, on how they are going to proceed with the matter, but as I said, the date now that for the court to resume will be on the 4th of February 2020. However, the leave to appeal matter that is set to be heard on the 22nd of November this year. Let me quickly now bring in our guest and legal expert, Advocate Makosazana Mbonani. Advocate, thank you very much for your time. In fact, you had said that there was a high possibility that the former president was going to appeal this decision.
Yes, that is true. We did expect that there was going to be an application for a postponement. It seems that the parties did agree and they did set the dates as you have so correctly stated. What is interesting though is that the co-accused of the former president said that they do not have any instructions as yet as to how to proceed. You remember that their application was significantly different from that of the former president. Theirs was on grounds of irrationality, irregularity, and that the NDPP acted ultra vires. So their application was heard with that of the former president because it had similar or hinged on similar facts. But they could be going a different route. As we know, they may appeal to the Supreme Court of Appeal, to the Constitutional Court, or both.
And the dates that we're given, from my understanding, the 1st of November is the date in which the former president must, by that time, have filed his leave to appeal, and then that matter will then be heard on the 22nd, I beg your pardon, of November. Advocate Downer speaking about that the appeal will be heard before a full court, as well as explaining that application will be done in papers. Explain that for us.
All right. This was a civil application, even though it emanates from a criminal application, so a criminal trial. So the civil application continues, and they have leave to appeal to a full bench, which means that the JP, which is a judge president, will constitute a full bench in this court to grant them leave to appeal. If it is denied, then they can continue to the next court, or whichever court they wish to appeal to. In this case, the SCA or the Constitutional Court. They have 15 days within which to file their leave to appeal from Friday, which is why we have the 1st of November. And from there, the matter is going to be heard on the 22nd. That means this is an application where everyone needs to have filed and the leave will be heard.
The matter today, Advocate, they were dealing, of course, with the situation around the leave to appeal, or the processes that need to follow in respect of this application for leave to appeal but also looking at discussion around the trial itself and the pre-trial dates. The advocate Downer also speaking about a formal process of pre-trial minutes and dockets that needed to be handed to the defense.
As you remember, today was the provisional date that was set down in May for the provisional date for the trial, the criminal trial. So that is why we were here today, and the postponement was granted because the civil case influences how this matter will continue. The pre-trial simply means that the parties meet and they decide on issues like what evidence is going to be used, how many witnesses are going to be called, and that there are no surprises in court. It's unlike in the movies. So the whole point of a pre-trial is to make sure that when they come to court, they are simply dealing with the trial, and the minutes are a report to the court that show the court that this matter is ready to be set down and that the trial is going to proceed without any hinges.
Of course, Advocate Matenjo, they're representing former President Jacob Zuma, saying they have been ready for the past 14 years for the trial, and saying that in fact they were happy that the state was now finally ready, but saying that the former president will exercise his full constitutional rights with regards, of course, to him now wanting to lodge this application for an appeal.
Well, as we know, it's been 16 years of the same matter, deciding on whether to indicting him, discontinuing the prosecution, then reviving the charges. It's been a long process. The reason why the state wasn't ready is because it needed to conduct further investigations initially, and then there was a whole decision on whether to continue with charges or not. At this point, the court has ruled, and that is where we stand right now, that there wasn't an unreasonable delay, and him saying that they are going to exercise every legal avenue available to the accused he's correct as well, within his rights to do so. I don't think there is any side that is to blame at this point.
And just speaking about Thales, of course, Advocate Katz, they're saying that they had not received yet firm instructions from their clients whether or not to file this application for leave to appeal, but they still have also the 15 days from the day that the judgment was handed down, so they could possibly still file this application as well.
Absolutely. They have until the 1st of November, just like their co-accused, the former president, to file a leave to appeal. But I think what he was trying to explain there is that their application for the permanent stay was different because they didn't center it on what the former president centered it on. Theirs was on irrationality, irregular proceedings, and as well as the fact that the NDPP acted ultra vires. So they may take a different route. They may, since they do not have instructions, they may file their leave to appeal in the SCA, for example, or the Con Court. The only reason these matters were heard together is because they arose from similar facts, but they don't have to be heard together.
And then just lastly, Advocate, on the 22nd of November, we will be back here at this court. Advocate Down is saying that Mr. Zuma necessarily does not have to be here on that date. So the 22nd of November, that will be when the application will be heard for leave to appeal?
Yes, an application for leave to appeal is a civil application because it emanates from the interlocutory applications. So Mr. Zuma was compelled to be here today because it was a continuation of it was a provisional hearing date for the criminal trial, and as the accused is compelled to be here. But for the civil applications and the civil proceedings, only his representatives need to be there.
All right, Advocate, thank you so much for your time. Advocate Makosazana Mbonani, they of course explaining to us what transpired in court, breaking it down for us in terms of the processes that now need to take place, as we know that we'll be back here in the Pietermaritzburg court in front of three judges, as we understand, that will be to hear the application for leave to appeal Friday's judgment, and then the holding date for the trial has been set for the 4th of February 2020. While the proceedings inside the court now are done, we have had indication now and confirmation then that the former president will be making his way from the court across to his supporters who have gathered. And I'm not sure if my colleague Ray will be able to move across for us, but there is a substantial number of people that have now gathered across at the Freedom Square, where the former president is going to then go across to address his supporters. Currently, he's still inside the court building, where he is in a debrief session with his legal counsel. And when he goes to address his supporters, that's an opportunity that we get also as the members of the media, as the public, to hear his feelings on the case. He often, in addressing his supporters, will give them a breakdown of what happened in court, and is likely, of course, to recap what took place on Friday and that judgment, as well as, of course, what happened today and his decision to take this matter further with regard to him now saying in court that they are going to be applying for that leave to appeal Friday's judgment. So I see now some of the leaders of the ANC, the religious leaders who are inside the court. They are now making their way across to where the supporters for the former president have gathered. So we'll be moving from here. My colleague Mlungisi Kumalo, he is also here with us, and he will be giving us an update on what is happening where the crowds are. But from my side, where I am, let's take things back to you, Desiree.